which is known as Centralized Death Reporting System. In this session or the panel discussion, we will be going to explore how the system works, its benefits for the investor and their families, and what stakeholders in security market need to know and to make the most of this smart move by SEBI. Before we start, just give me a moment to introduce our esteemed speaker today. We have with us Mr. Kun Bansal, General Manager NISM, who will be act as a moderator for today's session. And we have Mr. Harsh Rumta and Mr. Biharilal Devra, who will be acting as a panelist for the today's session. So, Mr. Kun Bansal is a seasoned finance professional with almost 3 decades of corporate experience. In these years, Sir has worked at some of the best brands such as Reliance and Kotak after starting his career at UTI. Sir has worked in areas related to financial research, securities analysis, and portfolio management. Talking about our second speaker, Mr. Hans Rumta is a seasoned chartered accountant and a principal officer of Fee Only Investment Advisor LLP, a SEBI registered boutique investment advisory firm. He is a director and former chair of Association of Registered Investment Advisors, which is called as ARIA, and served on governing councils of Shahamati Advocating and Account Aggregator Framework. Now, giving a brief about our third speaker, Mr. Biharilal Devra is a director at Abacus Asset Management Private Limited, LLP, which is an Indian-focused asset management firm with over 2 decades of experience across asset classes. Sir has managed portfolios for corporates, families, offices, and universities endowments. He's a chartered accountant, a CFA chartered holder, and a holder of multiple global finance credentials. He leads the AIF, PNS, and RI verticals at Abacus, overseeing portfolio analytics, risk frameworks, and strategic investment planning. Before we begin, just allow me give to some housekeeping, 2-3 housekeeping announcements. So we'll be taking questions, if possible, at the end of the webinar. And the recording of the panel discussion will be available on our NISM YouTube channel within 2-3 days. And all the participants who are attending today's panel discussion will be receiving a participant certificate within 3-4 working days. So without taking in a further time, I would like to hand over the panel discussion to our esteemed speaker. Over to you, sir.
Thanks, Amir. I am presuming I am audible, otherwise somebody should raise objection. Good afternoon, everyone. Welcome all once again to this panel, and welcome Harsh as well as BD. So on this important topic, so just to set the context, in India today, unclaimed assets, which include multiple assets, is actually over 2 lakh crore. Now, that is the staggering figure that is there for the assets for which, for a moment, if we say there are no claimants. Now, obviously, all these are not the assets whose owners have died. Some of them in the earlier physical days, people used to invest and forget. In some cases, people could not traverse the whole corporate action journey with their investments and things like that. But of course, a large part of that is because of the death happens of the holder, and then earlier the whole process of transmission used to be very difficult, and which is where now regulators have come together, not necessarily come together, but are trying to improve the system, and that is the whole discussion that we have lined up for you today. So let me start by asking Harsh. Harsh, before we get into more details, why don't you give some historical and regulatory perspective for the benefit of our participants? You are on mute, Harsh.
Okay. You can hear me now? Yeah. So
Yes.
thank you, Kunj, for having me here. Thank you, NISM. I think this is a very, very important area. And, just rewinding a little bit, going back to 2020, we were in the middle of the COVID epidemic. And that was a time when, I mean, deaths occur every time, but that was a time during which, an entire population was, transfixed by this whole issue of death. And consequent to that, one of the issues that clearly came into limelight was ease of transmission. And obviously, unclaimed assets also came into limelight at that time. And at the Association of Registered Investment Advisors, we were fortunate to sort of have the mentorship of Mr. Kamath and Mr. Pramod Rao, who was then the corporate legal counsel at ICICI, subsequently joined SEBI. He wrote a white paper and Arya published it, gave inputs, which was basically called Reimagining Nominations, making succession smoother and simpler. And I think it is a seminal work done by Pramod. He made several recommendations there, and I'm just going, and a lot of those recommendations have been put into practice. I just want to highlight four of them as they relate to the securities market. One is the ability to specify number of nominees, that has gone up from maximum of 3 to a maximum of a 10. Second, and very important, is allowing minors to become nominees without necessarily having to specify the guardian. Again, a very important thing, which was preventing couples, for example, to nominate their minor children because they could not, decide on who to nominate. Third was, looking at incapacitation. In those days, if you will remember, that was quite common with people, with the decision maker, being impacted by COVID, becoming incommunicado. Uh, some amount of work has happened as far as the securities market is concerned in terms of empowering the investor to demarcate any of the nominees to handle the investment in the event of their incapacitation. That is still work in progress, and it still misses one large area, which is mental incapacitation, when the person becomes incapable of contracting. That's a large area that will require change in law, it will require change in ecosystem. Fourth, of course, is the topic of today, centralized death claim reporting. It's a single biggest reform. It is unique to India. Uh, we don't see this anywhere else in the world. This is a global first where actually the securities market participants will reach out to the investor, tell them that to the investors' nominees, and tell them that, these investments exist, and these are the forms. If you fill them up, we will be able to sort of transmit it to them. Among two other things that are still pending in that, of course, and I'm just putting it here for record. One is the ability to specify successive nominees, and most important use case for that is, an investor wants their spouse to be the nominee. In the event the spouse predeceases, dies before the investor, then they want their children to be nominee. Now, that ability does not exist. Today, it requires a change in law. The Banking Act was amended, and therefore it has been provided in the banking sector. That law will need to be amended in the securities market as well. And the most important regulation of elevating or equating the nominees to become a legal heir. Now, that obviously has not been implemented because that requires change in law. So, that really was the overall perspective. I think securities market in India provides an example of ease of transmission. The securities market regulator SEBI, where nomination exists, there is a clear provision that where nomination exists, the only three documents that can be asked is the transmission form, the death certificate, and the KYC documents of the nominee. There is a specific provision in the master circular that prohibits regulated entities from asking for any other document. You can't ask for an undertaking and indemnity, anything else, nothing else. These three documents. And I have personal experience in my own case, where a fairly substantial amount of units were actually transmitted within 48 hours of the application being made. So it is working. Where nominations exist, it is clearly working. Centralized death claim is only going to make it even better.
Thanks, Harsh, for setting the context and highlighting the importance. So let's move forward. Coming to you, BD. So now taking on from here, can you explain to our participant this whole concept of CDR and that how it works and other details?
Sure. Thank you, Kunj, for inviting me on the panel, and thank you, NISM, for hosting the webinar. So as Harsh said, prior to kind of this circular, there were a lot of different practices with intermediaries in terms of the kind of documentation they were asking for. And there was no centralized way for someone to know if your assets are with which intermediary, right? Barely, few lakhs of customers, essentially use investment advisors. In absence of that, if your assets are lying somewhere else, people don't know what to do with it, right? And a lot of times these assets then can get remain unclaimed, as you said, roughly 200,000 crore from there. So what SEBI has done is in October 2023, they have launched this common death reporting, facility, where as investor, so if an investor, is deceased, they've got a concept of notifier. So whether it's a joint account holder, whether it's a nominee, whether it's a legal representative, or whether it's any other family member of that particular investor, can reach out with a minimum set of documentation, which is, the death certificate copy, original, or copy with notary, your identity proof and PAN card of deceased investor, and the notifier's identity proof and address detail. As long as these three documents on a common letterhead, which is predefined, is given to any of the depository, any of the stock, exchange, investor services center, or any of the mutual funds where they already have a folio, that particular intermediary essentially will take these documents, verify the authenticity of the death certificate online or offline through OSV, and then upload it on the KRA portal. Now, as you know, in capital market, KRA portal serves as a common, repository for all the customer records, and all intermediaries rely on it. The moment you invest in a particular security or a particular intermediary, that intermediary essentially downloads your record from the KRA and tags it along with their own ID. And what happens is once, intermediary to which you have submitted the records submits these details to KRA, KRA will again verify these details and mark that particular PAN card KYC as deactivated. And the moment it is marked as deactivated, an unsolicited feed from the KRA will go to all the people, all the intermediaries who had downloaded that PAN card KRA once for the purpose of the investment. And the timeline is very stringent. So on T day, if you give the documents to the intermediary, on T+1, the intermediary is supposed to upload to the KRA. And on T+2, the KRA will verify and then disseminate the deed. So by T+3, assuming your documents have been accepted, the PAN card has been deactivated, all intermediaries who had actually downloaded your PAN card have records of your this thing, will mark your folios, your demat account, your securities on freeze. And within 5 days, they are required to reach out to the nominee or the address on the account to ask for nomination formalities and give that these are the documents which are required. They need not verify the authenticity of death certificate again because it's already verified by KRA. And to that extent, the process becomes easier. So if you don't know which all assets you have, the moment you do it with one intermediary where you know it, or if you don't know any intermediary, just go to a depository office or a investor, stock exchange center, and they will do it for you. And that will get populated to everyone. And then they are supposed to reach out to the nominee asking for the process in which their assets can be claimed. While the documentation required for claiming the nominee and other things remains the same. But from your perspective, the process becomes far more streamlined and simple. This obviously helps notifier, to kind of notify only once and not multiple times. And more importantly, it also kind of reduces the fraudulent or impersonification cases, which otherwise, on some of these KYCs could have happened to that extent.
Yeah, thanks, BD, for explaining that. Coming back to you, Harsh. I'm sure our participants have heard the word nominee, nomination in first 15 minutes of this call, maybe more than 30 times. So obviously, it looks like that is an important word. So Harsh, I'll like you to talk more about the importance of this whole process of nominating nominee. Also, in that, if you can, in that process, if you can cover the difference between nominee and legal here, and if there is a will and a nominee, then what happens? Some of these questions. So you are on mute, Harsh.
So this whole nomination framework, I think, is again a very typical Indian innovation. And this arose from the fact that the entire inheritance mechanism is very cumbersome, time consuming, expensive. Okay, so I think sometime in the late 70s, the banking sector started this, that instead of deciding who's the legal heir, bring some document, bring that document, they said, why not allow the account holder themselves, okay, to decide to whom the money is to be handed over. Okay. The process of determining who's rightfully entitled to it, let's say the legal heirs, okay, or the people named in the will. Now, that is a parallel process. But in the meanwhile, the investor, the account holder themselves could specify that I want the proceeds of the investment or the account to be handed over to such and such person, right? So that person became the nominee. Okay. Obviously, the person to whom this amount is handed over, the nominee, holds it in trust or holds it on behalf of the actual owners who will be determined as per a parallel process. Okay. So a quickest example of that could be that, I have my spouse as a nominee. Okay, I have two children. I'm an Hindu. So, as per the personal law affecting me, if I were to die, and I don't, my mother is deceased, so one third portion goes to my two children, and one third goes to my spouse. Now, I could leave, that is as per the personal law. That becomes applicable if I don't leave a will. And let's say I don't leave a will, and I have my spouse as the nominee. So, in my bank account, in my securities account, mutual fund account, I have my spouse as the nominee. Based on that nomination, the bank will hand over the account proceeds to my spouse. The mutual fund will hand over the units to my spouse. Now she holds it in trust for the three legal heirs, one third for herself, one third for my one child, and one third for the third child. So that is the differentiation. The legal heirs is a different process. The who will ultimately get the proceeds is a different process. It's a court process, it's a legal process. Nomination, on the other hand, is carrying out the wishes of the account holder to hand over the proceeds. So I think that is a very key thing. And really speaking, not doing nomination is akin or probably more irresponsible than, squandering uh, your money on drink, for example. I think that's irresponsible. Not nominating is even more irresponsible. And I can't think of anything more irresponsible that somebody can do. And as I mentioned, very clearly we are moving in a direction where if nomination exists, it's already there. Why we are moving? We are already there. If the nomination exists, the payment of your assets will go to this person to whom you have decided will handle it after your death. If that is the person entitled to the money, any case, if they are also the legal heir, then that is great. I mean, they get the money fast, and they don't have to do the parallel legal process. But I presume that explains the difference between legal heirs and nominee and the reasons for nominee being so important. The parallel legal process is extremely time consuming and expensive.
Thanks, sir. So the last line is really important for participants to know that the parallel process is time consuming and expensive. So coming back to you, BD. So while we have talked about nomination, importance of being nominee, and these days, either you have to appoint a nominee or you have to clearly opt I don't want to. But even then, if there are cases where there are no nominees, then what happens?
So, Kunj, two things. One is from a centralized death reporting perspective, whether you have a nominee or whether you don't have a nominee, right? What SEBI made very clear was that anyone can report the death, right? So whether it is legal heir, whether it is nominee, whether it is joint holder, or whether it is any other family member, for the purpose of death reporting, any one of them can do it, right? Once the death reporting is done, the KRA is frozen, the assets are frozen. The companies or the securities market intermediaries will reach out to you with respective documentation, right? Now, typically, you will see that the documentation would have always a transmission form, which is specific to, let's say, a PMS or a AIF or a mutual fund. You'll always have, copies of documents of death certificate and the deceased. You will have documents, which are related to maybe affidavit or some sort of notarized indemnity bond or from all the claimants. And then if you have a nominee, things can happen automatically to the nominee. If you don't have nominee, then maybe a will is required. What they call in legal terms a probate is required, or sometimes there's a concept of succession certificate or inheritance certificate. Those kind of things are required. And once you give those documents, things will transfer. Like I said, in nomination, nobody is going to kind of wait. They will simply transfer it to the nominee, and nominee can decide who the legal heir is. Now, in securities market, what SEBI has realized is that there is a possibility that for certain lower threshold amount, that documentation should be reduced, right? So up to a certain amount of securities, which I believe the number was 5 lakh, and Harsh can double confirm. Up to a certain amount of securities, the documentation are made a little bit simpler, where as long as you give an indemnity bond and no objection certificate from all the claimants, I think the nomination, without the nomination also, things can be processed very fast. So from a death reporting perspective, whether you have nominee, you don't have nominee, you should go ahead and do it, right? From a claiming perspective, again, it depends on what kind of assets you are kind of claiming to that extent. The only thing you have to be remember is that this is specific to securities market. So once you do it, all your securities markets assets intermediaries will reach out to you. That doesn't mean your bank is going to reach out to. That doesn't mean your insurance policy is going to reach out to. That certainly doesn't mean your pension or EPFO is going to reach out to you. So only securities market. So while I am not purporting people to invest in securities market, but yes, if you are there, that's one of the benefits.
So that's an important point, BD, that and an important clarification for all of you participants, that this whole CDR process instituted by SEBI applies only to securities or assets held by you in securities market, which basically means mutual funds and shares largely. So I'm sure in the time to come, all the regulators will possibly work together that why can't this whole concept be extended to cover bank deposits, insurance policies, and other such things. So any thoughts, Harsh, on that going forward? So you gave a very good setting the background in terms of looking into the future, what happens.
If you will see the white paper that I spoke about, reimagining nominations, that covered all assets. That was not limited to the securities market. It covered the banking sector, it covered NPS, it covered EPFO. And an amazing thing is that the whole issue of transmission has wide variety. It was for the first time when we were looking at the white paper that I realized the kind of variety that exists. So, you have such, piquant provisions. EPFO, for example, I just want to point that out. EPFO, married woman, cannot nominate her parents. She has to compulsorily nominate her spouse or children if the spouse has died and they have no children, then she has to nominate her in-laws. She can't nominate her parents. Okay, I'm sure if somebody takes EPFO to court, this is something that will be struck down. But this is a clear provision. So, I mean, this kind of wide variety of practice is very prevalent. I think commonalizing it under the Financial Stability Development Council, the the area is huge. It has a huge impact on ease of the legal heirs to inherit the assets. Okay, is very much a part of ease of living index, and ease of living is something that I think the government is clearly focused on. And more retail you are, the smaller you are, more important it is. Because please remember, for somebody whose assets are large, suppose it runs into tens of lakhs or crores, they can afford to spend the time and the money to pursue. Most of the unclaimed amounts, the 2 lakh crores that you spoke about, are tiny, 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 tiny amounts. Together, it has become a mountain of 2 lakh crores. And I think clearing that is a responsibility of this generation. We have created the mess. We are supposed to solve it and not leave it to the next generation. Coming back to, you know, the benefits. So securities market very clearly, it's a benefit, and definitely you can see investors choosing securities market for, among other things, the whole transparency not only around investments but also around inheritance. One area which is suffering is real estate. There is no nomination provision in real estate, or where it is, like in the Cooperative Societies Act, it is completely ineffective. Because even if you get the asset based on a nomination in the Cooperative Societies Act, you can't transfer the asset. That is what the Societies Act provides. So effectively, there you cannot inherit real estate without going through some kind of a legal process. And I think this area is crying out for a common ground where the best practices, and this I can say without hesitation, the best practices that the securities market has shown, okay, needs to be multiplied across all the asset classes, including real estate. I think real estate is the last frontier as far as inheritance is concerned.
Thanks, Harsh, for further clarifying that. So while we will still continue the question, some of the questions have already started coming in. So maybe then other participant can also started putting in. We'll keep taking in between questions and covering our points. So BD, this question is from Sanjay Bhagat saying whether investments in bonds which appear in the consolidated account statement, is that also covered in the CDR along with the equity and mutual fund?
So again, my understanding is that anything which is in the capital market, which is anything which is part of your Demat statement. So anything which is part of Demat statement automatically gets covered because it is in the Demat, and Demat is, with a depository which is regulated by SEBI. Anything which is not in Demat, but for example, mutual funds or, for that matter, AIF, if they are also held outside of this thing, but they are with the SEBI regulated intermediary, they will be sort of covered automatically with the nomination process.
Okay. So other thing is that let's say there is a situation, and why let's say, I mean, quite a lot of times there is a situation that somebody passed quite a number of years ago, and now only slowly family is finding out that okay, our so and so relative had made investment in shares or in these mutual funds and all. So how does this whole CDR thing, does it still is it applicable to this case also, or else how does it work in such cases?
So the beauty of while Harsh, I'm sure will speak about Mitra and IPF, but the beauty of this system is that you can go and report the death anytime to any stock exchange depository or intermediary. So even if let's say the death has happened 20 years ago, okay, I'm assuming that they had KYC at that point in time and the investor was registered. But assuming that the KYC was done at that point, because KRA itself was maybe 2011 dated. If you right now go and provide that information of death reporting along with the death certificate and notifier information to KRA, And if they find that KRA is active, they will go ahead and, disable it or go ahead and, kind of block it. And if any intermediaries have kind of downloaded that KRA in the past, they will be notified, and they are required to reach out within 5 days time period to the required sort of, notifier with respect to what are the assets and how they can be claimed. Now, chances are that if the assets are not claimed for 7 years or 8 years, in the KYC, they would have got transferred to IEPF. That animal, I'm sure Harsh understands better, but let Harsh talk about IEPF and Mitra.
So on that note, Harsh, why don't you tell our participants more about IEPF Mitra and Mitra?
So, I mean, just to tell what these are, that on any of, and I'm going to restrict it to assets that people are familiar with. Let's talk of listed shares, for example, although it covers other assets also, but let's just restrict the discussion to listed shares. Any listed share on which dividends have not been claimed for 7 years, automatically the dividend amount also gets transferred to IEPF and the shares also get transferred to IEPF. IEPF is Investor Education Protection Fund. And Investor Education Protection Fund is a fund, is an authority actually set up by the Ministry of Corporate Affairs under the governance of Ministry of Corporate Affairs. Currently, the value of listed shares with IEPF plus the dividends is 83,000 crores. I repeat, it's 83,000 crores. This data is not available from IEPF website. The data has been painfully scrapped by us by going to each individual listed company, looking at their shareholding pattern, and in that they have IEPF, number of shares held by IEPF, and that has been collated by us across 3,000 listed companies, and that value comes to 83,000 crores. So one issue with IEPF is lack of information. Why is this number not being notified? This is aggregate information. Then how will people know that there is something? For example, I discovered my father had 100 shares of HDFC Bank. I by chance stumbled across it while I was writing on an article about IEPF. Okay, it was by chance when I was doing research that I stumbled upon it. So quite first you don't even come to know. And the same issue, unfortunately, in the securities market is with Mitra. Okay, that information is guarded as if it is, if you give access to somebody, it until that information is guarded, okay, the problem will never be resolved. Neither is the size of the problem made known. Even in Mitra, what is the size? Mitra is mutual funds, the unclaimed mutual funds. What is the size of the unclaimed mutual funds? Not aware officially. It's not released. How many claims have been paid under Mitra? Not released. How many searches have happened under Mitra? Not released. I would wonder if anybody has ever been able to successfully find out how much unclaimed mutual funds they have. Because I think the search facility itself is an issue. In IEPF, of course, getting the claim, even after you find out, getting the claim is also an issue. In Mitra, one presumes that once you find out, and because it comes under the securities market, the process will probably be easier. Is a presumption. I'm not aware of any specific case. So, as I'm saying, the big issue on unclaimed amounts arises because information about unclaimed amounts is not available. And in the case specifically of IEPF, the process to claim back the amount is tortuous, time consuming, and expensive.
Sure. Thanks, Harsh. Again, mixing one or two of these things, and then there are some questions also. And in fact, one of the most popular question is, what happens if the nominee dies?
In the
Prior to investor death or after investor death? That's the question.
So maybe we can address both.
So prior to investor death, if the nominee dies, simple nominee, investor can just go ahead and change the nominee. And what Harsh mentioned now with the nomination paper released by SEBI, you can nominate up to 10 nominees with whatever percentage you want to do. So if the nominee has died beforehand, you can go ahead and certainly kind of change the nominee. If the investor has died and nominee had died together, then obviously the legal, heir or a family member can go and report the death for sure. Once the death is reported, they have to follow the same process of getting the succession certificate or probate to kind of claim the assets. But that can certainly happen. So irrespective of who dies first, if one option is to get it changed, and you would see that in India earlier the concept was to have a lot of these things as joint holding, right? And the primary issue was that if one of the holder dies, the other holder can kind of claim it easily to that extent. And that was the whole concept of, this whole HUF and, this, joint holding. So in both the cases, like Kunj, if a nominee dies beforehand, you can change the nominee. If they have died together, legal heir or family member can intimate and then follow the process. If nominee dies afterwards, then obviously by that time you would have already claimed, because as soon as you report the death, within like 5 to 7 days, typically the transmission happens.
So, Harsh, coming back to you, maybe we can further focus on the fact. So, while that is not specifically the topic for our today's webinar, that the nominee has been mentioned in all the investment, but that doesn't take away the need to have a will. Should will be prepared in any case?
I think preparing a will is a must, at least under the current dispensation. Okay, because as the example that I had given, that if I want my spouse, and I have two children, as I mentioned, okay, if I want my spouse to inherit everything that I have on my death, okay, then I have to write a will, because if I don't write a will, if I just make her nominee, she will get all the assets. The bank will give it, the mutual fund will give it, the demat accounts will give it. That's not a problem. But my two children can stake claim for their one-third share, because if I have not made a will, my personal law will prevail, and under the personal law, they are entitled to one-third share. So if my intention is that my spouse should inherit everything, I have to write a will. The only thing where you don't, maybe, and I'm not advocating it, I want to make it clear. Please write a will. I'm just making it clear. But if people are lazy and people have strange notions, I mean, I've met people who say, if I write a will, I'll die. Okay. So people have strange notions on wills. I mean, reasons why people don't write a will, okay, is mind blowing. But, anyways, to come back, in movable assets, if your nominees and your people whom your legal heirs as per the personal law are the same, okay. For example, if I wished that one-third of my wealth should go to my spouse and my two children, okay, and I make them nominees like that, one-third, one-third, one-third each, then irrespective of whether I write a will, okay, they will get that. But please remember, there is no provision of nomination on immovable assets, okay. And in the legal process, okay, anybody can raise a dispute. I mean, raising a dispute is the easiest thing in the world. But the second thing which recognizes the Indian innovation is that, there is a saying that says, possession is 9/10 of law. Okay. So in a movable asset, if the mutual funds have been transferred, if the shares have been transferred, okay, then for another party to try and claim it through a court or a legal process is not that they can't do it, it has been done, but it is a difficult process. So I think to summarize, please do write a will. Okay. The only occasion where you might not do it is where the legal heirs as per the personal law applicable to you and the nominees are exactly the same, and those are the only properties you have.
So, BD, so everything has some advantages and some disadvantages. Are there any disadvantages of this whole CDR process that has been notified by SEBI, or some of the things can be ideal as well?
I mean, it's a very good process to kind of have that centralized reporting. So I don't see any sort of challenges over there. The only thing what like Harsh mentioned, sometimes if you report the death and if the nomination certificate is not there, nominee is not updated, sometimes it becomes very difficult to kind of get hold of the assets. You have to wait for the court orders, the probate and some of those kind of things, right? In a digital world where typically everything can happen through OTPs, sometimes you can initiate the transaction, and if you can kind of do the OTP, the transaction of redemption, some of those can happen. I don't see any specific sort of disadvantages per se, but like I said, one has to kind of do the process for sure, and please do check your assets in case nomination is not there. There was one specific questions about HUF which you wanted to kind of answer before I go ahead. So in case of centralized death reporting, see, HUF is I mean, even though HUF is a unique concept of India, and it's treated as a non-individual from that perspective. So in case of a demise of a karta, the death reporting will be initiated in the individual KYC of that karta, and not on the KYC of the HUF. While HUF KYC will be put on hold also, but technically HUF cannot demise. Only the karta can demise, right? In HUF, you can have another karta by succeeding, or you can dissolve the HUF itself if that is the wish. But typically, as per Hindu law, typically the eldest son or whoever is eligible takes over as karta. So for HUF, and similarly for companies and partnership firm, it is possible that the authorized signatory dies. In that case also, whenever you report, it will be the individual PAN card of that authorized signatory or this thing who would be put it on hold and deactivated. For company, obviously one can go ahead and change the respective kind of authorized signatory from there. So the process which you talked about is mostly from an individual standpoint and not from a non-individual standpoint. Non-individual, whatever is the prevailing authority, whether it is a trust deed or a HUF deed or a MOA or a partnership deed, will prevail over the whole aspect.
Sure. So now we have about 15 minutes left of our webinar time, and we had thought that we'll devote those time to answering the questions. So we have some questions. Other people may also type, and this is what we were anticipating, that while the webinar is on CDR, the centralized death reporting, the process and all, but there'll be a lot of questions on inheritance and others, which I still see. But still, let's see. So Rasmeet, Amir, you can start by taking questions one by one. And if there is a time after that, then we'll address one or two more points.
Sure, sir. So, sir, one question, like we can see some things in chat box also. BD has just answered the HUF question. So I will just go ahead and ask some more questions. Any of the panelists can take those. First question is, if any asset has a particular nominee and the same asset has been allotted to a different person in the will. So if the asset holder dies, who will finally get that asset? In nomination versus will, which has the upper hand? So, Harsh sir, you'll take the question.
So basically, as I mentioned before, the whole purpose of the legal process is to decide who will eventually get the proceeds. So will always override nomination, but in a very important but, as far as the proceeds of, say, let us say it's a mutual fund unit, as far as, and let us say X is the nominee and Y is the legal heir. As far as the mutual fund house is concerned, they will not give it to Y, because Y has to prove their claim via court or through a legal process. As far as the mutual fund house is concerned, they will be able to satisfy their liability only by handing it over to X. So they will give it to the nominee. Nominee in turn will have to give it to the legal heir, but through a legal process. If there is no dispute, X will hand it over to Y. If there is a dispute, it has to be settled in the legal system, not involving mutual fund. And that, I think, is a good thing, because that is a dispute between Y and X. The mutual fund house has nothing to do with it. And I think a very categorical statement from all regulators, this applies across regulators, is very good, because as far as the mutual fund house is concerned, the demat participant is concerned, the bank is concerned, insurance company is concerned, their liability is over. And then between the legal heir and the nominee, they will sort of use the legal process to settle. But so the summary is that obviously will overrides nomination, but that overriding happens through the legal process, not in terms of physical process.
Thank you, sir. So subsequently, somebody has written that what if a nominee, if he dies, what will happen? If nobody is there to claim, will the money remain with the fund house? And also, one person is writing that there's a circular now which states that nominee becomes a legal heir. So money received by nominee is done. So if you can just clarify on these two aspects also.
So let me take the second one. I mean, this nominee being legal heir, I think that's very much misunderstood. I think what the SEBI circular says is that joint holder, okay, becomes the legal. The joint holder is treated as the beneficial owner. That so joint holder is not a nominee. Please remember, joint holder is not a nominee. Joint holder is very much a co-owner. Okay, and their title of the joint holder comes from the principle of survival, that in case of co-owned properties where one of the owners dies, it is then the survivors among the co-owners inherit that property. And that is the principle outlined in the SEBI circular. Nowhere in the SEBI circular does it say that nominees will become the legal heir.
Sure, sir.
So Harsh, Rasmeet, Harsh,
Yes.
in good old days in Hindi movies, they used to be this killing of relatives, etc. This was primarily based on anyone on survival concept because the properties were jointly owned. So that used to be the title of movies. Now things have changed. So it no longer is the title.
So VD, now coming to you, you've already talked about the HUF. Some person had asked that can you please elaborate the procedure for transmission of shares in HUF account after the demise of the Karta? In case of a joint holding by three and after the demise of any one of the three, what the other two have to do? Is it treated as the transposition, transfer, or transmission?
So
And
from
related
the
to it, PD, they are also asking what is the maximum and minimum time to claim it and report to CRA?
Okay. So let me answer the third question first in terms of the time to report to KRA. The minimum time is you can report it on the same day. Of course, you need a death certificate. The maximum time is up to you. As long as you don't want the asset, you can take your time. But I would urge as soon as you have the death certificate copy with you, please go ahead and report it so that the process of assets claiming, etc., can start sort of happening. Why I understand you might be grieved and still kind of looking after the loss in the family, but I would suggest to kind of do the reporting as soon as possible. On the HUF question, like I earlier mentioned, if the HUF Karta is deceased, typically when you report the death to the KRA, the individual PAN of the Karta will be deactivated and the PAN of HUF will be put it on hold. The HUF co-partners or the members of the HUF essentially have to go and replace the Karta as per the applicable sort of law and give the documentation required to for activating the said KRA. The shares will continue to remain on HUF name unless you dissolve the HUF itself. So you have two options: replace the Karta. Once you replace the Karta, HUF account is active again. The new Karta can transact in the HUF. Second is dissolve the Karta. In case it dissolution happens, then shares will get sort of transferred to whosoever is the sort of co-partner in whatever proportion they would have had been. As regarding the joint holding question, like Harsh mentioned, the joint holdings are essentially co-owners of the property. And in majority of the cases like shares, typically we have seen this case in portfolio management service where, there are two holders, so three holders in some of these cases. The name of the deceased owner is simply removed or cut down or striked off from that particular account. And then, the assets are, held with the remaining owners. I'm not a legal expert on whether it's a transfer or transpondent or transmission. So I'll leave that question to sort of legal experts. But my understanding is typically the name struck off can happen, and that process is very, very well articulated in the depository sort of regulations already there.
Okay, thanks, BD. So then the other question is regarding whether the publication of nominees' names in the mutual fund folios do they create unnecessary litigation if on later day the investor changes the nomination easily with the change of form, etc.?
Sorry, Rasmeet, can you repeat that question?
Yes, it's like whether the publication of nominee's name in the mutual fund folios, like will that create an unnecessary litigation if on a later day the investor changes the nomination? Because nowadays what the person was want to say that you have a change of nomination form facility.
Yeah.
So he wants to understand
No, I think
whether,
the way I understand is, whosoever is the fund house would go by the latest list of nominees which are out there. So whatever is the latest list which has been updated by the investor himself, that list is what I think they will go by in terms of transferring of the asset. I mean, investors have option to change the nominees n number of times during his lifetime. And that right is with him at any point in time. So one cannot take away that particular right. So whatever is his last nomination will prevail over all the previous nominations.
okay. Then the other question which comes is, if in a mutual fund and demat account single holder, they cannot add single or third holder in the existing folios, unlike banks, post office deposits, etc. So why is this so? Only the existing joint holders can continue. Addition of second and third holders can somehow mitigate the survival issues. So we just need to enlighten them about the new nomination rule and all that stuff.
So again, my understanding is the way the banking system and other systems treat it very differently from the way securities market treat it. It's always easier to kind of do this from the beginning if you want to kind of hold the assets in joint names rather than trying to do it differently. It avoids tax hassles and operational difficulties. While in banks and etc., they have a set process to kind of add further nominee. In securities market, it's very difficult given that the assets are already owned and there are concerns with respect to PMLA or otherwise. So I would suggest if the assets are in the individual name, sell those assets and eventually then reinvest in the name of joint holders if that's what the intention is to that extent. But yes, there are those kind of anomalies like Harsh said in amongst different regulators. We are still kind of trying to come to the same conclusion while SEBI has taken the first step in coming there. But I'm sure more regulators will follow and eventually we'll have that common standard.
Okay. The next question comes is like, what happens if the KYC of the deceased is already on hold prior to the demise of the KYC
So
holder?
typically, yeah. So typically, there are two ways the KYC can be on hold. One is, they would have applied for a KYC change at some place and, the doc process is not complete. And the other is that you have intimated the death to the intermediary, but you have not given them the documentation. Right now, typically what happens is whenever a disease death happens in the folio, typically we get an email from investor or his distributor or maybe his RIA or any other sort of family member saying that so and so this thing happened and we'll submit the documents in advance. So the first thing we do at that point in time is go and put that KRA on hold and say that something has come to us and freeze all the sort of folios in that. And whenever the documents comes to us, we will submit and that time the PAN will get deactivated. So till the time PAN is not deactivated, it will always be on hold. It could be because of documentation. For example, certain municipalities, the death certificate cannot be verified online. So we have to wait for the original to see and then verify. Certain places, the notified details are not there. Certain places, the PAN card is not there. So if any of those documentation discrepancies are there, it will be on hold. But otherwise, you can go ahead and, get it changed very quickly once you submit the documentations.
Okay. Thank you, BD. Then I think one or two questions more we can take in the time we have right now.
Rasmeet, I just want to add something which is very beneficial about the centralized death claim reporting, and it ties in with one of the questions that I see here, that somebody died without informing their family members about what they hold, and they're not even aware कि भाई इसके assets है कहाँ पर. So that is where a centralized death claim reporting is extremely useful.
Yep.
Okay, because what it does, and I'm assuming that that person had taken care to nominate. And now, if you will see in the securities market, unless you have given the contact details of the nominees, you will not be able to, use the mutual funds or the demat accounts, etc. further. So I think what that ensures is that when a death claim is reported, when a death is reported, let us say to the investor service center of a stock exchange, right? Now that obviously gets transmitted to all the KRAs, and any place where that PAN number has a holding is automatically made aware about those that person's disease, and they in turn are required to reach out to the nominees on their record with the facilities for you know
Transmission.
facilities for the transmission. So this has been inverted in the securities market. Normally the claimants have to go to the claim to each of the places where the investments are. The centralized death claim reporting has inverted that process and has made the entities proactively reach out to the nominees. This was a central recommendation of the white paper, and fortunately it has come into fruition. So I think this is a very important thing. The benefits of this are probably being felt at a much lower scale today, because fortunately not that many people die, but I think we will see the benefits of this really play out when this becomes multi regulator. That is the time when, by reporting death in the securities market, if you also come to know of an insurance policy, you also, so the day where CKYC starts playing the role that KRAs are playing today, and therefore, it becomes available to the entire financial markets, is where the power of centralized death claim reporting will truly come into its own, and will hopefully ensure that unclaimed amounts are not added to the existing mountain of unclaimed assets.
Thank you, sir. In fact, a very good concluding note as well. So, with this, I would like to thank all the panelists as well as the audience for participating in this enriching discussion. And thank you very much for your time and enthusiasm. With this, we'll just conclude the session, sir. Thank you so much.
Thank you.
Thank you. Thank you, everybody. Bye.